Well, let's actually call this hearing to order. Good morning, and I have actually a wonderfully written opening statement, but I was going to do something slightly different on it. Being someone who actually bathed and lived in the Job Act when it was individual bills moving through the system, and then actually once we consolidated it and ran it out, think of this. In the previous 2 years, it really was, in many ways, our only really great bipartisan success. And there was great optimism, great hope, April 2012 when the President signed it. Now we are, this much time, a year beyond some of the rule sets, and yet I go around the country and I've spoken to dozens of different groups that are very optimistic and looking forward to an opportunity to use this new path of options to raise capital for small businesses. And our bottleneck right now, is within the rule writing. And I accept there's great difficulties. You've had leadership transitions. So I'm going to ask for, my friends here in the committee. Today's goal is not to beat up the SEC. It's basically to have a dialogue on what do you need, what are our expectations, both in drafting and time that you're able to share with us. Are there any things we should be doing as members of Congress? Do you need us to provide a piece of legislation that provides more detail? Do you need us to stay out of your way for a while? What gets it done? Because in many ways, the goal here is actually to have the positive that will come, I believe, once the rule sets are done and the crowdfundings, the Reg As, the others are able to start to stimulate a tier of our economy and our small business access to capital. And with that, I hand over to the ranking member for an opening statement.
Thank you, Mr. Chairman. I'm going to stick to the script. I'd like to welcome everyone to this morning's hearing. For the past 2 years, our nation's economy has experienced positive and steady private sector job growth. However, these gains have not been enough to overcome our nation's above-average unemployment, which currently stands at 7.6%. Minority unemployment for African Americans and Latinos, while retreating, remains at a 13.3% and 9.2% respectively. These facts, along with last week's job numbers, illustrate the work we have yet to complete. Creating nearly 2/3 of all new jobs, our small businesses must remain front and center to our recovery. For our national economy to experience a more robust recovery, our entrepreneurs and small businesses must play their traditional job-creating role, and for that, we must have access to capital. For entrepreneurs who have a solid business plan yet lack immediately marketable products, equity capital has been a crucial aspect of getting their businesses off the ground. Many are turning to crowdfunding to finance their businesses. However, the number of small businesses that can access capital is severely limited due to the prohibitions on equity investing via crowdfunding. In response, Congress has passed the Jumpstart Our Business Startups or JOBS Act in 2012, which provided a new exemption from SEC requirements to register public offerings for equity investing via crowdfunding. This exemption has the potential to unlock the virtually untapped resources of millions of ordinary investors to small businesses. However, as evidenced by the rigorous congressional debates before passage of the act, a balanced approach to investor protection must be in place before allowing the general public in this inherently more risky realm of small business investing. Pursuant to the JOBS Act, the SEC was mandated to create rules to do just that. However, the SEC has yet to complete the rulemaking process, thus preventing full implementation of the JOBS Act, missing several congressionally mandated deadlines. In today's hearing, we will discuss the SEC's delays in implementing the JOBS Act and the needs of our small business community. While no one is happy waiting for these rules to be drafted, we must remember that it is vitally important that the SEC strike the appropriate balance between investor protection and producing a functional system that provides the capital for small businesses and entrepreneurs to create jobs. I want to thank you again, Mr. Chairman, for holding this important hearing, and I yield back the balance of my time.
Thank you, Ranking Member Clark. Maybe I should have stuck with the script. Our first two witnesses representing the SEC, Mr. Nalangara, did I get close? And Mr. Ramsey. You're both probably very familiar with the lighting system, and my understanding is you're going to be sharing your 5 minutes on the opening statement. When you hit yellow, just talk faster.
Okay.
And Mr. Nalangara, please.
Thank you. Good morning, Chairman Schweikert, Ranking Member Clark, and members of the subcommittee. My name is Lona Nalangara. I'm the Acting Director of the Division of Corporation Finance of the Securities and Exchange Commission. Joining me today is John Ramsey. John is the Acting Director of the Commission's Division of Trading and Markets. Thank you for the opportunity to testify on behalf of the Commission. Implementing the Jobs Act is one of the Commission's top priorities. As you know, the Jobs Act made significant changes to the Federal securities laws. While certain provisions of the Jobs Act were effective immediately, others required Commission rulemaking. In addition, the Jobs Act required the Commission to conduct several studies and send reports to Congress. Since enactment, the Commission staff has taken steps to inform the industry of how the Jobs Act operates. For instance, the staff provided guidance about the IPO on-ramp provisions by publishing answers to frequently asked questions. These questions address such things as how emerging growth companies could use these new provisions, including those related to research reports, test the waters materials, and scale disclosures. The staff also provided guidance on the amendments to the registration requirements of 12G of the Exchange Act. With respect to rulemaking, the Jobs Act required the Commission to adopt rules that revised Rule 506 of Regulation D to allow general solicitation and advertising for offers and sales of securities under that rule, and to implement a new crowdfunding exemption and a new exemption for broker-dealer registration for funding portals that facilitate crowdfunding transactions, and finally to create a new exemption for offerings of up to $50 million. To fulfill this responsibility, we have formed rule-writing teams consisting of staff from across the Commission, including economists from our Division of Risk Strategy and Financial Innovation, who are considering the potential economic impact of the rules we are considering. To aid the rulemaking process and increase the opportunity for public comment, we have allowed interested parties to submit comments and recommendations on the Jobs Act provisions through the Commission's website even before we have proposed rules. The Commissioners and staff have participated in numerous meetings with a wide array of interested parties. The input the Commission and the staff have received in these written submissions and these meetings has been very helpful to the rule-writing teams as we consider the implementation of these mandates. As you may know, there has been significant interest in the provisions requiring the Commission to revise Rule 506 to allow for general solicitation and advertising. Under the rule proposal the Commission issued last August, companies issuing securities in an offering conducted under Rule 506 would be permitted to advertise and solicit potential purchasers, provided that the company takes reasonable steps to verify that the purchasers of those securities are accredited investors. The proposing release explains that issuers should consider the facts and circumstances of the transaction when determining the reasonableness of the steps to take to verify that a purchaser is in fact an accredited investor. Prior to and after issuing this proposal, the Commission received significant public comment, and the staff is now developing recommendations for the Commission's consideration as to how to move forward on the implementation of this mandate. The Jobs Act also required the Commission to submit several reports to Congress. First, it required a report on how decimalization has impacted the number of initial public offerings. That report, which was submitted to Congress in July, recommended that the Commission conduct a roundtable to discuss the impact of decimalization. That roundtable took place in February. Second, the Jobs Act required a report on how our disclosure requirements could be modernized and simplified to reduce the costs and burdens for emerging growth companies. The staff is in the process of completing that report. And finally, it required a report examining the Commission's authority to enforce the anti-evasion provisions of Rule 12G51 of the Exchange Act. That report was submitted to Congress in October. In addition, the Jobs Act mandated the Commission to provide information and conduct outreach to small and medium-sized businesses and businesses owned by women, veterans, and minorities about the changes made in the Jobs Act. The staff is working to develop and implement an outreach plan tailored specifically to these business communities. The Commission and staff continue to work diligently to implement the Jobs Act mandates, and we look forward to completing the remaining provisions as soon as possible. Thank you for inviting us to appear today, and we'd be happy to answer any of your questions.
Thank you. And why don't we, I'll start with the first 5 minutes and have a couple questions. Mr. Ramsey, one of the big questions, and I get this around me, what should our expectations be on rule sets coming out, And what do you think will be the first ones we see?
Thank you, Chairman Schweikert, and again, we appreciate the constructive tone that you've set for the hearing. It's very difficult for staff to create any specific expectations in terms of timing, and so I won't attempt to do that here. We understand there's a lot of interest. We understand that there's a fair amount of frustration with the pace at which the rulemaking process has taken. I will say that from the people that I talk to within the Commission, there is a shared sense of interest in moving this forward. Our new chairman, Chairman White, indicated in her recent testimony that she saw this as a high priority, and so I'll resist the urge to make any specific predictions in terms of timing, but certainly stress that this is a very high priority for us.
Am I being unrealistic that by October, by fall, and part of this is I feel like many of us have gone out around the country talking about the crowdfunding and these, and a year later I feel like I'm breaking people's hearts by getting them excited and enthused and trying to line up capital. Any window of the time of year?
Chairman, those are questions that we hear as well from some of the same parties interested in taking advantage of these new rules. And these are important rules. These are important rules because you gave us a mandate, but also important rules because what's underlying that mandate. What's underlying it is providing new ways for businesses, but really focused on small business to raise capital and grow their companies, create jobs, and strengthen the economy. But what's also important about these rules is these rules are in many respects fundamental changes to the way private offerings have been conducted. And the rules, some are very specific, but some also provide discretion for the Commission.
Well, Mr. Nett and Gary, in that case, what do you think will be the first to come out? And understanding the actual date is unknowable at this point.
Chairman, it would be hard for me to tell you which would be the first to come out. Chairman White has indicated that all congressional mandates are her priority, and specifically the Jobs Act provisions are her priority. And the three main rulemakings that we have are the Title II general solicitation, the Title III crowdfunding, and the Title IV Reg A Plus rulemaking. Those are all a priority. We have issued a proposal already with respect to the general solicitation provisions. So that has already been proposed, and we've received comment on that. The sequence of those rulemakings, that will be for the chairman and the other commissioners to determine. But the staff is working. We have independent rule writing teams on each one of those, and the staff for each one of those rulemakings is working as if their rulemaking is the first one to go. So the staff is working very hard to get these in place, to get recommendations.
Is there any way I could organize like an X Prize, the first one to get it done wins something?
What would be the prize, Chairman?
Oh, yeah. Espresso.
Exactly.
Okay, last one, and then I'll turn to the ranking member. And this one may be a little more ethereal. I would love some guidance because many of us are starting to work on what should be the next act in sort of the Jobs Act 2.0. Is there something we as members of Congress can do in the way we write it, in the way we ask for rule sets to make it run smoother? Do we need to provide more direction? Do we need to provide substantially more detail? What would make this process that our bottlenecks and the timing become compressed? What do we do to do this better?
Chairman, the mandates you give us, we look at them as you give us, and as you give them to us, and we do our best to implement the mandates you give us and the intent underlying those mandates. So some of the mandates you give us, and even within an individual in an individual title within the Jobs Act, have specific requirements, and some give us discretion. We look at all of those questions that you provide us in the rules and implement them in a way that both the ones that are specific and both the ones that give us discretion in a way that allows us to further the purpose of the legislation.
But understand, this is more than just an academic discussion. It really is affecting people's lives. Many of the next generation of entrepreneurs, folks out there who've built businesses, as we'll hear on the second panel, who are trying to get to that next level where they can hire people and grow and sort of help both as a nation and their own futures. I mean, I hope you feel the same sort of weight on your shoulders as we do on this side, that yes, getting it right is important, but getting it done is crucial.
Absolutely, Chairman. That the staff and the staff feels that way, and the direction from the Chairman and the Commissioners is to get these rules done, and that's what we're committed to do.
Okay. All right. With that, we may end up with a second round if we go fast enough. Ranking Member Clark.
Thank you very much, Mr. Chairman. I want to do a follow-up to the Chairman's question. Mr. Nalangara and Mr. Ramsey, can you give us an idea of the work volume you're dealing with in concurrently developing the rules for the Jobs Act while still engaged in fully implementing Dodd-Frank?
Ranking Member, the Commission is facing an unprecedented workload when you factor all of the congressionally mandated rulemakings. There's over 90 Dodd-Frank provisions that have rule writing requirements and over 20 studies. Although we've completed 80% of those and 17 of those studies, there is still plenty to do. And some of the rulemakings that are left to do, particularly the ones in John's division, are related to systemic risk. And then when you add the Jobs Act rulemakings, the three main rulemakings, but there's ancillary rulemakings and studies and reports to do, that is an unprecedented level of work. And the ones related to the Jobs Act, as I mentioned earlier, those are fundamental changes to the way the capital markets, the private offering markets will work. Those are mandates you've given us, but for us to implement them and implement them in a way that achieves the goals that you mentioned in your statement, which are to provide an efficient and effective way for small business to raise capital, but at the same time ensure that investors feel safe and feel like they're getting a secure investment and they're investing in a real business that provides opportunity for return and growth to them. That requires us to make sure that we're getting the rules done right. That being said, we need to get them done. We appreciate that you gave us deadlines and those deadlines have passed, but we are focused on getting those rules done.
Yeah, if I may, yes, Ranking Member Clark. I think just from the standpoint of my division, Title VII of Dodd-Frank and all the derivatives reforms, which require us essentially to adopt a whole new regulatory regime that did not exist before over a huge international market, is an effort that is consuming and has consumed huge amounts of resources, continues to over a period of time. So, and this is all mandated rulemaking as well. So we'd ask people to understand that we don't expect much sympathy for it, and we're not really asking for any sympathy for it, as Lona said. Regardless of what else is on our plate, we know this particular set of rules, as Chairman Schweigert said, is something that is affecting people's lives and ability to raise capital currently. It ought to be prioritized accordingly, and we take that to heart.
Yeah, I just thought, excuse me, it was important to sort of put things in context. This is not happening in isolation of many other responsibilities, obligations, rulemakings that you're currently engaged in. So I think it was just sort of important for us to get a sense of the universe that you're working within. And, I think one of the things that would be helpful for all of us, and maybe even for yourselves, is, for you to sort of set a time frame for yourselves. Maybe it's an internal time frame, but one that sort of drives this process to a timely conclusion, given the fact that things have already past deadlines. It's going to be important that there's some motivating factor to really get this done. Mr. Nalangara, some experts are concerned that a conflict of interest could arise between funding portals and the companies seeking funding. Specifically, financial interests of the funding portals could lead to more lucrative, yet risky deals receiving preferential treatment when presented to potential investors. How does the SEC plan to address this concern in the final crowdfunding regulations?
Ranking Member, I will start with the answer, and then I will turn it to John, whose division has primary responsibility for the funding portals. But the legislation you provided us in the Jobs Act lays out a regulatory regime for funding portals. It provides oversight by FINRA, and the rules that FINRA will adopt will be able to monitor and watch those activities. Funding portals are intended to be a portal between the investor and the company seeking money. They are intended to present the picture and the idea of that entrepreneur, of that business, and let the entrepreneur tell the story, but also serve as a gatekeeper, serve as someone ensuring that both the company knows what they're doing, but also that investors understand what they're investing in, understand the risks associated with the investment, and also understand the security they're investing in.
Yes, Congresswoman, an awful lot of the time that we have been spending in our division has been devoted to meeting with representatives of various of the funding portals or of that part of the community that are interested in investing in this space. As Lona said, many of the Jobs Act provisions are intended to ensure that intermediaries for crowdfunding offerings operate in a way that protects investors' funds, that takes account of the privacy interests of investors, that makes sure that investors get the right kinds of disclosures that they need, that where there's a contingency on the minimum amount of offering that's a subscription that's required, that all takes place. These are all critically important provisions, and I would just say that our sense is there's a lot of very capable, smart, creative people in this space who want to do the right thing and who have an interest, as we do, in making sure that the rules are written in a way that excludes the bad actors as much as possible, because I think they would agree with us, is my sense, that nothing would undermine the ability to use this as a capital raising tool faster than if the rules are written in such a way that don't exclude the bad actors as much as possible. And so that's why part of the reason we want to be very careful about how they're written.
Very well. Thank you both. Mr. Chairman, I yield back.
Thank you, Ranking Member Clark. And I would like to extend a welcome to Patrick McHenry, who is the Chairman of the Financial Services Oversight Committee, and I appreciate you spending a moment or two with us. Mr. Lukemeyer, you're next.
Thank you, Mr. Chairman. I know that I have had a number of questions from some of my constituents with regards to the delay on issuing the Rule 506 Reg D situation. Can you explain what happened there? Why that should have been done last summer, and here it is almost 9 months later, and we're still not anywhere near it. What's going on?
You're correct, Congressman. You provide us a deadline, and which was 90 days after enactment, and we didn't meet that deadline. We did issue a proposal in August. That proposal, as I outlined in my opening remarks, provided a framework for that implementation of the rule. We received significant comments before and after the proposal, and the Commission is considering those comments right now. We've had some transition in our Chairman's office, but our Chairman, Chairman White, has indicated that the Jobs Act priorities, and in particular the ones related to 506, are a priority to be moved forward.
Why would the transition of a new chairman change the ability of you to be able to do your job? How many people do you have working on this project? Let's start there.
We have a number of people in my division who are principal rule writers. We have economists in our division of risk strategy and
Do you have
financial
a particular group that works on just this rule, or they work on all sorts of other rules as a whole?
On this particular rule, we have a group of attorneys in our chief counsel's office.
Is this their full-time job, that they work on just this one rule?
It is not their full-time job to work on just this rule.
How much time do they spend on this then?
They spend as much time as is necessary. So,
well, they're not spending very much if it's 9 months later and we still haven't got a rule, then are they? My concern is that it doesn't seem to have the attention of the SEC, and this is a really big deal because, you know, we as a Congress haven't agreed on a heck of a lot over the last 2 or 3, 4 years here, and we actually finally got to agree on something. This is a way to help small business, and we're very concerned about the lack of action here because we have small business groups out there that would love to be able to put together offerings, expand their businesses, buy new businesses. The entrepreneurs are sitting on the sidelines. I can tell you from the past 2 weeks of going around talking to a lot of my constituents, they're sitting on the sidelines waiting to get into some of these businesses, but can't because the rules aren't there. And I know that you proposed it at one time, and yet it was pulled by, I guess, the chairman, killed the rule. But so what's the problem with it? Why did she kill the rule once it was proposed?
Congressman, I don't think anyone killed the rule. I think what you're referring to is
they proposed it and then it was withdrawn. Okay.
No, I think what you're referring to is at one point the Commission was considering moving forward on the rule with an adopted rule immediately, rather than proposing the rule for public comment and considering that comment. And just to frame how our rule writing process works, almost all of our rules, virtually all of our rules, are proposed and adopted in a manner where
you withdrew your proposal, correct?
No, we did not withdraw our proposal. The Commission considered it in August, considered a proposing rule, a rule that would require.
The Commission withdrew it.
No, the Commission did not withdraw it.
We don't have one. How come it's not gone forward? Put it that way.
Congressman, we do have a rule proposal. Our rules, almost all of our rules, are proposed and provide a comment period for the public. The public gets to look at the rules and comment on it, give us their ideas.
When do you think you're going to get this one finalized?
Our new chairman has given us has indicated.
She's going to give you 90 more days. Is it a priority?
She has indicated it's a priority. So if she's indicated it's a priority for us.
So, what's a priority? Is it 90 days or 9 months?
I can't say.
We're at a year on this now. I mean, it doesn't seem to be a priority of the SEC, and this is a big deal. This is how we're going to get our economy going. I don't think you see the importance of your job. You help create economic activity in this country, sir. Your agency does. And I don't think, and now you're standing in the way of it. And I think that's a big problem. And if you hear frustration in my voice, it's there, because I'm only venting to you what is being vented to me. And I think that we have to find a way to get things back on track. I see my time is up, but I appreciate you being here this morning. Thank you.
Thank you, Mr. Lukemeyer. Mr. Bentivoglio.
Chairman, Ranking Member, thank you for holding this very important hearing. Our country has a jobs crisis, and in my district, it breaks my heart to drive through industrial parks and office parks and see for sale, for lease, or available signs rather than help wanted. And last year, both parties recognized that the creativity and ingenuity of our citizens could be unleashed if they had greater access to capital. They recognized the power of startup businesses to create opportunity and jobs, and the result was the Jobs Act. The SEC has the important job of creating rules and regs that walk a fine line between creating access to capital and protecting investors. And I have a few short questions. Thank you very much for being here. Companies that are required to file reports with the SEC are given deadlines, correct?
Yes.
Are there consequences for missing those deadlines?
Yes.
So would it be correct to say that the SEC understands the concept of deadlines?
Yes, Congressman.
Well, I'm not sure I agree. The Jobs Act became law over a year ago, and you have missed 2 important deadlines. One was more than 9 months ago. Does the SEC believe they can miss deadlines stated in law because they are too busy?
Congressman, all the deadlines that you provide us in the legislation that you mandate are important deadlines. We work as hard as we can to meet those deadlines.
Does the SEC believe they can miss deadlines because of changes in leadership? Yes or no?
No.
Does the SEC believe they can miss deadlines due to lobbying pressure? Yes or no?
I'm not sure the question is you can answer with a yes or no, but the closest I can get is to no. How about that?
Great, great. The SEC expects reporting companies as their regulator to respect their deadlines. Congress is your regulator. Is it fair for us to expect you to respect our deadlines?
We do, Congressman.
Well, it's debatable, and I think it is reasonable for Congress to be more than a little upset about a Federal agency's failure to meet the deadlines set forth in the laws we create, especially when it has a big impact on our economy and job creation. I have a question about the modification of Reg A, which increases the limit to $50 million from $5 million. There was no deadline in the Act about this change, which is probably good for you, or it would have been strike 3. Were you in this process? Are you in this process, and when should we expect the rules to be final? Can I have a date?
Congressman, I can't provide a date. I'm not the one who's setting the dates. I can say that Chairman White has indicated that getting rules proposed and completed on Regulation A plus that is a priority for her. So it is a priority for us.
No date. No real deadline. Just when you get around to it. That's the impression I'm getting.
Congressman,
I'm getting a lot of verbal moonwalking, but I'm not getting anywhere.
Congressman, I can't provide you dates, but I can provide you that we are committed to get the rules done as quickly as we can.
Okay. Mr. Ramsey,
Yes.
on crowdfunding, what are you going to ensure that the cost, or what are you doing to ensure the cost of compliance is not too high, especially when many investors may only want to invest $20 or $50?
Well, Congressman, I will, in terms of the requirements on intermediaries, I'll defer to Lona on the rest of it. But I think we have been, as I said earlier, talking had dozens of meetings with people who are in this community currently to understand what practices they follow now, what best practices are in their area, what kinds of requirements might pose a significant cost burden issue for them. That certainly is an issue that we've been looking at closely in terms of looking at the comment letters that have already come in. So on issues like how do intermediaries, what do they have to do in order to protect privacy interests, what kind of arrangements can they have for holding customer funds, what obligations do they have in terms of providing issuer disclosure, and how can that be provided. A significant part of our focus has been on trying to make sure that that's done in as cost-effective a way as possible.
Thank you very much. Mr. Chairman, I yield back my time.
And thank you, Congressman. Mr. McHenry.
Mr. Chairman, thank you for allowing me to step in and visit your subcommittee. Thank you for your leadership on financial services issues and your interest here, especially your authoring within the Jobs Act, the piece dealing with Reg A in particular.
Well, and you had something to do with this, I think, somewhere.
Well, crowdfunding is my deep and abiding interest within the Jobs Act. Reg D rules as well. That's certainly something we care about. The crowdfunding piece, certainly you all have heard from me and from my staff. So, Mr. Ramsey, Mr. Nalangara, thank you for your service to our government. I certainly appreciate it. I am certainly aware, as members of Congress are, that you are the lead staff in terms of your divisions within the SEC. However, the SEC, with the 5 Senate-confirmed members of that board, set the agenda. In particular, the chairman sets the agenda for your agency, your very important agency that is supposed to facilitate capital formation and protect investors. And of course, that is a balancing act. And I certainly do appreciate your willingness to testify today. But Mr. Nallinger, in terms of my colleague, Mr. Luchtemeyer's questions, I do want to give you an opportunity, and there was some hesitation with his questions, but just to correct the record and make sure that this is accurate. According to my understanding is the staff recommendation to the board and last summer, when it dealt with Reg D rulemaking, the staff recommendation was to propose is to offer a final rule during the August SEC commissioners meeting. Is that true?
That was our initial recommendation, yes, Congressman.
Yes. And there was a decision made to pull back and open back up for comments on that what then became a proposed rule. Is that correct?
Yes.
Okay. Just want to make sure that that's correct, because in terms of these questions, the staff recommendation was for a final rule, that the comments have been heard. Based on the email traffic that I have now received, these are documents that have been provided to Congress, that was clearly the case, and the then Chairman Shapiro, had an enormous pullback and a huge change of approach based on being contacted by the Consumer Federation lobbyist. And we have, and I wrote a letter to Mary Shapiro to that regard at the end of last year, and I'm certain that you all are aware of that. So I just want to make sure that record is corrected. Mr. Ramsey, in terms of intermediaries when it comes to crowdfunding, there is broker-dealers are allowed to participate, and there are pure intermediaries that are allowed as well under the law. I just want to confirm that the intention is to time the rulemaking for both those entities is the same, that the date will be the same for both those different types.
Yes, Congressman, I believe that is the intent. The registered broker-dealers, firms that are already registered as broker-dealers, would not need any further authorization. Firms who would be operating as funding portals would need to register with the Commission and with FINRA. We've been working closely with FINRA to make sure that their program will be in place so that, as you say, firms will be in a position to choose which of those paths they want to.
So there's a cap on the amount, and back to you, Mr. Nallinger, in terms of the rulemaking. The SEC has to write rules when it deals with capping individual investors, the amount that they can invest in a crowdfunding offering, right? Yes. And so, looking at the cost of crowdfunding offerings, this is a tricky issue based on what the final Senate language came back with a cap of $2,000 or 5% of a person's income. It's segmented out. Is the SEC looking at having a very simple way of tracking individuals' crowdfunding investments?
Congressman, that's a question that we have received from many of the crowdfunding or the future crowdfunding participants on asking how are they going to be able to track investments, because that cap is intended to be across any crowdfunding investment you made. There are a number of ways to proceed. One of the ways that proponents have recommended to us is self-certification. You tell the issuer, you tell the crowdfunding portal how much you may have invested. That is something we are certainly considering, and certainly that's what the Commission will consider as well.
Okay, so that is
That is on the table as one of the ways to implement that provision.
are there other ideas on the table?
Well, I mean, we as part of our rulemaking, when there are choices, we need to consider all the choices. We need to look at those choices and look at and look at the costs and look at the benefits of every choice. And I know you all want us to do that. So we will do that.
Yes, I in
those
particular want you to
provisions as well.
weigh both the costs and the benefits. Yes, I've been a major proponent of that. But thank you for acknowledging it. Mr. Ramsey, I'm sorry.
No. So, Congressman, with respect to costs on funding portals, certainly on questions of how does one ascertain whether the investors are within the limits or not, it certainly has been an important focus of our discussions with them and the rule writing efforts to think of those costs. We're certainly cognizant of the concern that if there were a significant new structure that were required to be put in place, that they would have to fund in order to do that, that could create some significant costs that would deter them from participating.
Thank you, and thank you both for your service, and thank you for testifying. We have the acting chair next week in front of the Oversight Subcommittee on Financial Services, and at least Walter, and so we'll follow up on some of these questions certainly there, and I know that your staff sitting behind you will pass that along, I'm sure. Chairman Schweikert, thank you so much for your graciousness in allowing me to sit in, and thank you for your leadership.
Chairman McHenry, is this the nicety language? I'm still working on that Southern thing.
The bow tie is Southern enough, right?
Patrick, thank you for giving us some of your time. It's appreciated. We're now heading towards the lightning round.
Great.
My understanding was it last year, court ruled that they weren't particularly happy with how the SEC was doing its cost-benefit analysis. Is that correct?
I think, Chairman, you're referring to the proxy access decision, and
yeah, actually, and it's on top of my desk, and I wish I had grabbed it. I know it was D.C. Circuit, which would be everything.
And I think from that decision, our commission, led by our economists in the risk in our Division of Risk Strategy, Financial Innovation, and our General Counsel's office, put out new guidance on how we are supposed to conduct our economic analysis.
Where I'm heading is, what has that done to the timeline internally within the process?
I think the role of economic analysis in our rulemaking has always been there. What we've done with the new guidance is we put a framework around it, and we provided it, and we provide it to everyone. It's on our website. The questions we ask and the considerations we make with respect to costs and benefits, with respect to identifying the baseline, with respect to identifying the regulatory fix or the market failure that your mandates are trying to achieve. All of those questions were questions we asked in our rulemaking before. Okay. What we've now done is formalize them as in the form of that guidance. So our rulemaking
and that puts you in compliance with what you believe the D.C. Circuit requested.
We think our guidance on we think the guidance that the Commission has provided related to our economic analysis keeps us in compliance with what the APA requires for our rulemaking.
And this is going to be probably closer to a statement than a question. One of the reasons there's parts of the Jobs Act that I believe are really important, whether it be within the crowdfunding, some of the broker-dealer solicitation mechanics, is when I sort of look at small business, it's not only the business side of the ledger, but there's also small investors. And we have this habit of, particularly even the design of our committee, we fixate on the business, as we should. But if I don't have $1 million, if I actually, on one of the definitions, when we start saying, okay, you get to be a qualified investor, qualified to assess the risk and could bear such risk. if I'm the young electrical engineer, I may not have accumulated my $1 million to be a qualified investor, but I'm an expert in that, so if I'm going to invest in a business that's doing that, it's my fear is you're sort of bifurcating the society. You're polarizing parts of the society of here's the folks that are there, they get to be qualified, they get to know what's out there, they get to invest. Because you haven't met a threshold that's defined by wealth, you don't get to participate. And that was one of my great hopes, that things like crowdfunding and those actually created a much more egalitarian access to participate in, ultimately, the American dream. So this is more than just the access to capital for businesses. This is the access to financial security and growth for a huge portion of our nation's population. So, Ranking Member.
Thank you, Mr. Chairman. Along those lines, Mr. Ramsey, sophisticated investors typically have protections in place and distribute their funding over time to protect their financial interests. Due to the nature of crowdfunding, investors are less likely to be sophisticated and lack the ability to negotiate similar protections. What steps has the SEC taken to address this shortcoming of the crowdfunding model as regulations are being drafted?
I appreciate the question, Congresswoman. I think there are a number of measures that are in the legislation which will be important parts of the rules that we provide in this area to make sure, number one, that investors are given very clear risk disclosures, that intermediaries are take steps in order to make sure that they fully understand all of the risks that are provided, that they receive appropriate disclosure from the issuers that allow them to evaluate the investment in a reasonable way. Particularly important that the customer funds and securities are adequately protected. In this regard, the legislation was clear that broker-dealers who are fully registered are able to handle customer funds and securities. Funding portals would not by themselves. They need to have a separate bank escrow agent to hold those funds. We think that is an important protection as well. Certainly making sure that customers' personally identifiable information is protected and that their privacy interests are protected as well. All of these are respects in which we are trying to make very sure that, as I said before, that this is a capital raising tool that investors will want to use because we are very concerned that if there is, particularly at the outset, bad experience in a few significant cases, that could deter people from using this mechanism, and that's something that would not be in accord with what the congressional intent is.
Mr. Nalangara, clearly much of the debate over crowdfunding regulation comes down to investor protection versus access to capital for small business. Again, along the lines of the Chairman's rationale, has the SEC investigated current platforms like Kickstarter for predictors of fraud to incorporate into the equity-based crowdfunding rules?
Ranking Member, we've had the opportunity to meet with a number of non-securities-based crowdfunding proponents. There are a number. Kickstarter is one, but we've met with a wide variety of them. And what we found, what we learned is that the evidence of fraud or the existence of fraud in those on those platforms is very low. The ability for people participating in the offerings, the crowd, their ability to comment on a potential campaign, as they call them, is a remarkably powerful way to determine whether this idea is something that's viable, and that will be a part of the rules that the Commission proposes, an ability for the crowd and to provide the wisdom of the crowd as crowdfunding as crowdfunders like to refer to it, to provide their idea on whether this is a good business, whether it's viable, whether it has a real opportunity for success. And that vetting by the crowd has been very powerful in the non-securities-based crowdfunding. And the crowdfunding proponents are hoping that will be the diligence tool for investors. So you will have people who are smart in that area be able to look at what this business venture is offering and be able to ask questions and be able to give their views on whether that's a viable opportunity.
Mr. Chairman, I have one final question. The JOB Act explicitly mandates an effort by the SEC to reach out to the minority veteran-owned small businesses. Can you give us an update on this ongoing process?
Yes, Ranking Member. Our Office of Women and Minority Inclusion, as well as my division, and in particular our Small Business Office, are focused on implementing that mandate. So there are a number of ways we hope to do that. Our OMWI office has a number of ways which through commission activities we reach out to those communities. We are going to piggyback on those same outreach efforts and use those as opportunities to explain what the Jobs Act will bring. Much of this effort will come when we get the rules in place, so there's something to talk about, more tangible. But we are beginning that process, and we have a number of ways through our Small Business Office where we provide information and discuss what the Jobs Act has done, and as the rules come online, we'll be able to be more meaningful in that regard.
Thank you very much, Mr. Chairman. I yield back.
Thank you, Ranking Member. You touched on one thing there. I will encourage you, in more simple language, I love the idea of, as there's crowdfunding platforms, that there's also associated absolutely open discussion, whether you refer to it as blogs, where, if I'm an expert in that area, if I'm not, if I'm just, passing by, but that access to information, it is sort of the new world of ratings. I mean, how many of us these days, before we buy a product, go on and look at customer reviews? It is the sort of the new era of egalitarian access to reviews and information. So, gentlemen, thank you for your time. I appreciate, as you start to get windows on timelines, I know a number of the members of the panel would be just elated to hear it. And with that, we'll set our second panel. Thank you.
Thank you.
All the hearings are. And this is that chaotic time of year. So, but I appreciate, and we'll start this.
Mr. Chairman, no one sitting up here?
As we seat our second panel, what I was going to do seems to be more of a tradition of this committee is I was going to actually sort of do each introduction, and so I'll introduce Ms. Peters, have her give her testimony, and we'll actually work our way down the line. So shall we now call the second panel up? I don't know if you heard it before. Lighting system is a 5-minute clock. as is sort of the humor around here. When you see yellow, just talk faster. I would like to introduce the second panel of witnesses here with us today. First up, we will have Jean Peters, Managing Director of Golden Seed's Angel Capital Network. Jean Peters is an angel investor based out of Richmond, Virginia. Through Golden Seed's Angel Network, Ms. Peters invests her own money and time to support women-owned entrepreneurs' startup businesses. Jean also serves as a board member for the Angel Capital Association, which she is testifying on behalf of. Welcome to the committee. We actually look forward to hearing what you have to say. Ms. Peters.
Thank you, Chairman Schweikert, Ranking Member Clark, and subcommittee members. Thank you for inviting the Angel Capital Association to speak. I am Jean Peters. I'm a Managing Director of Golden Seeds, the fourth largest angel group in the country. Our 280 members collectively have funded more than $50 million in equity to 60 women-led startups. Golden Seeds is a charter member of the Angel Capital Association, on whose behalf I am testifying today. ACA is the world's leading association of accredited angel investors. We have 200 angel groups from across the continent and their 8,500 individual angel members. We share the committee's concern with the length of time the SEC is taking for rules, but also with the substance of the prepared rules. So let me briefly describe angel investing. By definition, angels are accredited investors who invest from our personal pocketbooks. Most are former entrepreneurs or were successful in business, and we want to help others up that ladder. We invest in the most primal point of capital formation, small business startups with high growth potential. We also speak for the 250,000 accredited investors across the U.S. who already fund startups each year. And these are just a subset of 8 million people who meet that definition and are an untapped source of capital that could become active. Angels are the only source of equity for most startups and supply up to 90% of all outside equity for seed stage companies, according to the Kauffman Foundation. In fact, angels fund 20 times as many startups as venture capital does. In 2011, angels provided $23 billion of capital to 66,000 startups, while VCs put a couple of billion into 1,800 startups in total. Angels work from Main Street, not Wall Street, and angel-funded companies are crucial for job growth. According to the Census Bureau, startups make up less than 1% of all companies, but they create 10% of all new jobs in a given year. Without angel funding, these companies would never get off the ground. We bring disciplined due diligence and deep experience to the table. We have to. Capital comes out of my own pocket. We understand that what we do is highly risky and extremely illiquid. We give our time and expertise without compensation and often without liquidity for 8 to 10 years. We do this to make a return, but we also do it to give back, to keep up with our industries, and because entrepreneurs value what we do. So this brings me to a key part of the Jobs Act, Title II, which ends the ban on general solicitation for issuers who sell securities only to accredited investors, angels. We understand that entrepreneurs desperately need capital. Companies that could get bank loans or at least small business credit cards are now shut out. So the potential for crowdfunding, general solicitation are exciting. We also understand that these vehicles have high risks for the unwary, and we appreciate the efforts to safeguard those risks. But the rules provide the issuer to take reasonable steps to verify that investors are accredited. The problem is the SEC hasn't provided any clarity on what those steps are. Instead, they say they'll determine that on a case-by-case basis. This lack of any safe harbor leaves investors and entrepreneurs in a deeply uncertain position. The ACA surveyed its investors who said they are likely to not invest if they have to turn over financial records to entrepreneurs. Their lawyers are telling them not to invest. This would cause a dramatic slowdown in angel funding. We recommend that the final rules specify safe harbors. At last fall's SEC Forum on Small Business Capital Formation, there was a unanimous recommendation to make reputable angel groups a safe harbor for general solicitation. Angels have a history of disciplined due diligence, deal screening, governance, and almost a total absence of fraud. As investors enter this class, the ACA will lead in providing those professional standards. We'll be the adult supervision for crowdfunding and general solicitation and social networks. We'll be there when companies that crowdfund need that extra capital. We'll be the sorting mechanism for these startups that are most promising. We'll ensure that companies seeking funding are legitimate, appropriately structured, managed, and valued. And that will mean that the innovation that's now bubbling up on every professional district and job-seeking community will stand the better chance for success for the entrepreneur, for its employees, and for the investor that's willing to take that risk. I thank you.
Thank you, Ms. Peters. That's interesting. Bill Klein, the next witness with us is, do you prefer Bill or William? Bill Klein, CEO of Fairbrook Technologies, or Fallbrook?
Fallbrook Technologies.
Fallbrook Technologies is an automotive company focused on the development, manufacturing of energy-efficient vehicle transmissions. I actually spent some time on the Internet looking at some of your technology and comments. It's fascinating what you've accomplished. Prior to joining Fallbrook, Bill served in various executive positions in the automotive industry with Vistion?
Excuse me, Vistion.
Vistion Climate Control Systems at Ford Motor Company. Bill is testifying on behalf of Connect, a San Diego-based California innovation trade organization. Bill?
Thank you. Good morning, Chairman Schweikert and Ranking Member Clark, as well as the other committee members. First of all, thank you for the invitation to be here. It's an honor to appear before this committee today and testify on the challenges those of us have raising capital for early-stage, innovative new companies in the face of this financial and regulatory environment. Increased capital for America's, I commend you for calling this hearing to check up on the status of the Jobs Act implementation to ensure the goals of the Jobs Act get accomplished, namely to increase access to capital for America's innovators. My name is Bill Clem. I'm the Chairman and CEO of Fallbrook Technologies. I've served as Fallbrook CEO since 2004 and have over 20 years of automotive-related experience. We're a private company based in San Diego and Austin, Texas. We manufacture and market a proprietary continuously variable transmission products and support our global partners in the design and development of our proprietary transmission technology. Fallbrook currently holds over 500 patents and 15,000 patent claims. Our mission is to deliver the best performing, most versatile, most reliable mechanical power transmissions on the planet. We employ 133 people in the U.S., including approximately 25 of the best transmission engineers in the sector. We've passed the commercial tests of physics and economics. We've partnered with worldwide industry leaders, including national leaders like Allison Transmission of Indiana, Dana Holdings Corporation of Ohio, and Team Industries of Minnesota. Our proprietary variable transmission technology is potentially applicable to any product that uses a transmission. It replaces conventional transmissions technology that uses gears to transfer raw power to managed power. As you might imagine, transmissions are ubiquitous. They are in virtually every system, electromechanical system today on the planet. The most obvious examples are motor vehicles, but they exist everywhere. The range of application should give you a sense of the size of the opportunity we're trying to address. Today, for the market opportunities that we are currently investing in, it's about a $30 billion market opportunity for us. Our technology allows the next generation transmissions to increase fuel efficiency, reduce emissions, and improve overall vehicle performance, serving as an important function in protecting the environment. Our great country prides itself on entrepreneurship and innovation. In my opinion, Fallbrook is the poster child for those values. From an idea starting in San Diego in 1998 with negligible revenue through 2009 to over $43 million in revenue last year, and all that money being poured back into the business to help it grow, sounds like a good start, but the maze in which small business and innovative companies must navigate to acquire capital is becoming increasingly challenging. We have an opportunity to grow faster and drive innovation faster. The only thing preventing us today is the access to affordable capital. Our ability to access capital is the most significant challenge we face as a business. I personally spend 50% of my time on it. With additional capital, we would expand our manufacturing base in Texas, build out our engineering and development team, which would create new high-tech jobs, accelerate our product development and partnership opportunities. It's important to note that expansion would also have a significant impact outside of our particular company, in that both our suppliers and customers would also benefit from that job growth. This committee should remember that high-tech engineering and manufacturing jobs are the kind of jobs this economy needs, not only because they enhance America's competitiveness, but they also pay above-average wages compared to other sectors. That's why Congress's bipartisan work to pass the Jobs Act was so important, and why regulatory hurdles should not slow us down now. The jobs and innovation will materialize once the Jobs Act is fully implemented. The changes enacted by the Jobs Act will make acquiring capital less challenging for America's new innovators. The current Regulation A cap of $5 million is outdated and unworkable, and Congress was absolutely right to modernize that for today's innovation climate. To meet our needs at Fallbrook, an incremental $5 million round simply would not fund the type of development and growth we are targeting at Fallbrook. Additionally, the opportunity cost of the old Reg A filings, including legal accounting fees and printing costs for a company our size, amounts to hundreds of thousands to millions of dollars. Mid and large cap companies that raise public equity benefit from their scale of the transactions relative to their administration costs, but small and emerging companies across this country in various tech sectors are robbed from the benefits until that Reg A rules are implemented. This means that new, well-paying jobs aren't created, new technologies sit dormant, and new products do not affect the lives for the common good. The changes in the Job Act will enable Fallbrook to accelerate our development and commercialization, driving innovation, growth, which creates jobs. Thank you very much.
Thank you, Mr. Klein. Our next witness is Kevin Rustagi?
Rustagi, yes.
Rustagi, okay. CEO of Evolution of Noise and co-founder of Inc. Magazine's 2012 Coolest College Startup of the Year, Ministry of Supply?
Yes, that's correct.
Kevin graduated from MIT Technology in 2011 with a degree in mechanical engineering. Prior to graduating, Kevin co-founded Ministry of Supply, a dress shirt company, with MIT classmates in 2010. Kevin is currently CEO of Evolution of Noise, a product development company that is working on several new customer products, including a re-engineering of business cards using laser etching.
That's correct.
And I was teasing Kevin earlier that when I run into someone as brilliant as he is at his age, I'm always fearful I'm going to wake up one day and be working for you. Kevin, share with us.
Thank you. Good morning, Chairman Schweikert, Ranking Member Clark, members of the subcommittee. I'm so glad to be meeting with you and that you'll take the time to hear my testimony. As Chairman Schweikert mentioned, I graduated from MIT in 2011 with a degree in mechanical engineering focused in product design. My senior year, I got into Stanford Business School. I've deferred that for 3 years to work on interesting new high-tech and high-growth startups. I've had experience with different types of funding, family and friends loans, angel investors, and most recently, donation crowdfunding through Kickstarter.com. The company I last founded, Ministry of Supply, creates high-tech business apparel for men. I'm actually wearing one of the shirts right now. And I just want to talk a little bit about what we did on Kickstarter. Our goal was $30,000 last July. You have to meet or exceed that goal to maintain those funds. We raised, in a little over a month, a grand total of $429,000. The Jobs Act will greatly increase entrepreneurs' chance of success by going beyond things like crowdfunding and really talking about crowd investing when you need further access to capital, as we did, and I'll talk about today. With Kickstarter, it's very interesting. For consumer packaged goods, what I focus in, it's really become a pre-order destination. And what was phenomenal about our product and service is that we did what in the startup world is known as going viral. So a global viral PR strategy enabled us to get over 100,000 views of our videos with pre-orders from over 24 countries. Unfortunately, what ended up happening afterwards, well, it was so exciting. We had so much funding that we began to rapidly scale a supply chain and hire new employees. However, the money that we were offered from multiple investors around the world, many of whom were smaller investors, we were unable to take based on lack of legal precedent and vetting tools. We experienced the deep irony of having a great business opportunity and having to turn investors away. I just want to delineate the difference between equity-based and donation-based. Donation-based crowdfunding is a great opportunity. However, it is not nearly as reliable as equity-based, as dictated through the Jobs Act. One of the interesting things as well with high-tech, high-growth startups is dilution. When you have a limited number of investors, say an angel investor community that surrounds the entrepreneur or venture capital associations, you deal with smaller potential valuations. Simply, the entrepreneur is subject to whatever valuations the market will bear given the number of investors they have. If you open up to the crowd, I believe this will have a leveling, smoothing effect that will enable further growth. The timing of the Jobs Act is very important with regards to the global stage. Mass Challenge, Boston-based startup competition that's one of the largest in the world, actually received applications last year from 35 countries. Mass Challenge, like the marketplace, is judged solely based on traction and market adoption. Competition is now a highly global democracy. It's very important that America matches the speed of global competition. I believe the Jobs Act will help us do that. I believe also that crowd investing would be used. There are limitations on other types of investing. Angel investing, you're talking about connections in the liquid market surrounding the entrepreneur. Venture capital, it's the idea of being proven. They reject 98% of startups that walk into their door. And crowd donation, you're really dealing with the time window. Does your product exactly match that window? And as far as I know, in terms of entrepreneurs that I've met over the past 6 years, given new effective crowdfunding tools, we would make quick use of them. In conclusion, crowd investing within the Jobs Act clearly demonstrates or will demonstrate America's continued commitment to developing the next generation of small businesses and startups. It remains vital to consider all elements of supporting startups, especially other items that are caught up in legislation, including the startup visa. New businesses are very difficult ventures to undertake. There are a ton of risks. And I have found, as well as my colleagues, that we spend a lot of our time fundraising, as Bill mentioned. As I've noted, I've used a variety of tools to create new ventures, both for product design and business development. My hope is that my colleagues and I can continue to create new ventures in a way that leads and inspires the world. I eagerly await the day that I can fully utilize crowdfunding and crowd investing to help create successful new ventures. I thank you for this opportunity to explain the concerns of the startup community, and I welcome any questions.
Kevin, thank you for sharing with us. I'd like to yield to the Ranking Member, Clark.
Thank you very much, Mr. Chairman. It's my pleasure to introduce James Angel. He's an associate professor of finance at Georgetown University's McDonald School of Business. He currently is on leave where he is serving as a visiting associate professor at the Wharton School of the University of Pennsylvania. He specializes in the structure and regulation of financial markets and has expertise in the IPO process and capital formation. Dr. Angel's current academic research focuses on market regulation, and he has previously testified before Congress about issues relating to the design of financial markets. He holds degrees from Caltech, Harvard, and Cal Berkeley. Welcome, Mr. Angel.
Thank you. It's an honor to be here, and I want to thank the committee for taking the time to investigate this very, very important topic. Now, as you know, the Jobs Act was passed in reaction to the twin crises we face. First, there's the jobs crisis of the Great Recession, but there's also a crisis in capital formation. The most obvious symptom of this is what's happening in our public equity markets. We have less than half as many public companies as we used to have 15 years ago. You may have heard of the Wilshire 5000 Index that represents all the U.S. exchange-listed companies. Well, guess what? There are no longer 5,000 companies there. There are no longer 8,000 like there used to be. Now there are less than 3,600 companies in the Wilshire 5000. Our markets have been steadily shrinking. Now, there are many contributing factors to this crisis, and I'd be more than happy to sit down with any of you or your staff and go into it in a lot of detail. But it's something that's one of the things that was addressed in the Jobs Act with many of these contributing factors. Now, And I want to thank Congress for really doing such a good bipartisan job of addressing many of these different factors. There's no one silver bullet that's going to fix everything. But many of the parts of the Jobs Act make it easier to avoid becoming a public company because of the burdens we placed on public companies. Well, that's fine for smaller companies, but I think we really need to pay attention to also fixing the public markets and not just making it easier to avoid the public market. Now, a lot of the stuff in the Jobs Act could have very easily been done by the SEC on its own authority. The SEC has very broad rulemaking authority, very broad exemptive authority. They could have done almost everything in the Jobs Act by themselves without needing an act of Congress. So the real question to ask is, why didn't they? How is it that this specialist agency, which is tasked with making this trade-off between consumer protection, economic growth, competition, capital formation, market efficiency, they're told to make the right trade-off. How is it that they have consistently failed over the years to do this? And it's not the fault of any one commissioner or any one staff member. Congress really needs to take a look at the big regulatory picture and say, why is this agency not getting it right? Why did we have to step in with this very precise law, and here a year later, why did we have to grill these staff members as to why they haven't implemented the law? Well, if you think about it for a minute, the SEC had long ago decided that they didn't want to do any of the things the law said, so it's not really a surprise that they've been dragging their feet. And indeed, despite their protestations that it's a high priority, they've been spending their time on other things that were not mandated by Congress in either Dodd-Frank or the Jobs Act. For example, they just released a 377-page rule filing on regulation SCI, which, yes, it's an important area, no doubt about it, but it's not one of the things that Congress mandated with specific deadlines to get done now while we have 11 million people standing in an unemployment line. So anyhow, but let's look at some of the other issues here, like crowdfunding. Simple idea. And yes, there are serious consumer protection concerns there. We don't want the fraudsters running in and ripping off Aunt Sally. But we don't want to study it to death either. No matter what they do, they're never going to get it perfect. No human is going to do that. There will be, unintended side effects that nobody's thought about. And like good regulators, they're paralyzed by the fear that that's what's going to happen. Now, there's a common sense solution to this. The common sense solution is to, put out interim temporary rules, learn from the experience, and then fix it. They're not going to get it right the first time or even the second time. So, we need to adopt an attitude of innovation, try it, see what works, and when we find a problem, fix it. Same thing on tick size. Again, another technical matter. I'd be more than happy to sit down with you or your staff to talk about the pros and cons. But one thing we know is that the optimal tick size is not the same for every company. So the real public policy question is not, let's study it for 5 years. No. The real question is, who decides? Do we let the SEC come up with a one-tick-fits-all policy like they did in Rule 612? I don't think that's the right approach. Who has the incentive to get it right? The issuers do. So why don't we let the companies themselves fix it? So anyways, thank you very much, and I look forward to your questions.
Thank you. I hope you'll forgive me for throwing this in, but I find this just fascinating, because of what you're all doing. Kevin, something I've been trying to partially get my head around and also trying to encourage the SEC and others is, let's say you and I have an equity crowdfunding platform.
Great.
If you were designing it, or your personal experience of out there raising money using technology, is access to information, my comment before of affiliated blogs, how would you do that? Because if I'm a believer that information is the ultimate regulator and vetter, what would you do?
So I completely agree, Chairman Schweikert, that information is key. So this is very important. With Kickstarter, we had over 1,000 conversations with different potential customers, given that it's a pre-order facilitator. So if we were to make and create a crowdfunding platform, there would have to be a couple things that we would do. One, we would have to have transparency about who's involved in the company, especially at the managing partner level. So if, for instance, if Bill's going to go on our crowdfunding platform and create a company, a cupcakery, as is mentioned in the briefing here, we'd have to know, who's his main baker, who's his any past financiers, as well as who's really managing the team. Specifically, I completely agree with the idea of a blog detailing progress about the company and also basic financials.
Okay. Ms. Peters, when you're actually out there building, working with your angel network, just as a side question, and this sort of passes back to what Kevin was just saying, information on the management, the individuals. When you're weighing, how much are you all investing in the concept or investing in the people?
Well, with startups, a lot of times there's no revenue, there's a very nascent business model, and you're really investing in the jockey very much. And so angels do get together in groups, and we do a very substantial amount of due diligence. We end up looking at everything from management capabilities, from the competitive arena, from past history of the management. We do reference checks. Angel capital investing, accredited investor investing is not something you do on PayPal. I mean, it's negotiated. You work very closely with the companies. We go on their boards, and we offer advice. We offer strategic advice, and we spend time with those companies throughout their history. So transparency is just imperative. I mean, we require information rights with any company that Golden Seeds invests in, and most angel groups do that.
Thanks, Ms. Peters. Mr. Engel, being someone who's actually very interested in the tick size mechanic, because not only seeing the crisis of the number of publicly traded equities out there, but also how the curve seems to be pulling further and further out, that the big caps are traded and the smaller ones are orphans. And obviously tick size. Are we to the point now where I need to try to put together a bipartisan piece of legislation and drive it through our process? Because many of us have had the discussion of, do you do a sliding scale? Do you just allow the company, the exchange, and the interested parties to basically pick a tick and say, hey, we're going to be a 5 cent, we're going to be a 10 cent. And the last part of that is, would you go, 5 to 25? How much range would you create?
Oh, why, thank you. Thank you. For those watching on TV who aren't as familiar with the tick size, the tick is the minimum price variation. You can trade a stock right now at $10 or $10 and a penny, but you can't trade it at $10 and a half penny. And it sounds like a very technical issue, and it is, but what that really indicates is how much you have to pay to jump ahead of other people who are bidding the same price you want to pay. So if right now other people are out there bidding $10, if you want to jump to the front of the line, you have to bid $10 and a penny. Now, sounds very technical, sounds like a minor thing, but it has a big impact on the way people trade. And the real question is, what is the optimal tick size? I've published papers with mathematical formulas of this, and it's really a function of many different things, everything from the size of the company to how many people know about it, and it's not the same for every company. So if we tried to have a one formula fits all, we would miss a lot of stuff, and we probably wouldn't get it perfectly right. So I'm of the opinion that the best thing to do is to ask who has the right incentive. That's what good economic analysis is all about. It's not about, did the SEC properly manage or properly count how many paper clips will be used in implementing a law or a rule. It's the question of, did they get the economics right to make the right trade-off between consumer protection, capital formation, market efficiency, and competition. Now, if you make the tick too wide, that puts a floor on the bid-ask spread. That's a transaction cost. So if you make the tick too wide, you're driving up costs. That's going to hurt the stock price. On the other hand, if you make the tick too small, you're not providing enough protection to people who provide liquidity in the market. and that will hurt the stock price.
So would you use a sliding scale? Would you use a volume adjustment? Would you just allow the company in the exchange to pick a number and then review it on velocity of trade?
Right. I would let the companies pick their own tick size because they have the incentive to get it right. It's their stock that's being traded, and if they get the wrong number, they should have the flexibility to experiment with different stuff.
We may be calling you because I'm frustrated on this one and maybe actually trying to draft even
Happy to assist.
Mr. Klein, you have a great interest in what we refer to as the Reg A.
Correct.
It's now a $50 million offering, a simplified process, and as you and I talked about, the $50 million allows you to be on the big exchanges,
Yes.
and the great hope of then becoming a covered stock where researchers are following you, which makes additional offerings possible. But in a company like yours, with the growth and the technology and the capital intensive you need, is $50 million an appropriate threshold?
Yeah, so we are actually a capital light business. So we run a mix of intellectual property licensing as well as manufacturing. So the business model that we employ has the flexibility to be able to do all of those things. So a $50 million capital raise. So for the first time in 9 years, my angel investors, my 203 angel investors, I don't have to go out and raise money because we're going to be a cash flow positive business this year.
Right.
So this is the time to raise money. But what we really require money for is that next jump in growth. We went from $8.7 million in revenue to $43 million in revenue in 1 year. Sorry?
To almost where you're going. Let's say you had the $50 million new capital. You were able to go. What does that do to your employment base? I mean, what does that change in your local economy?
So for us, we've relied on licensing and contract manufacturing. We have small manufacturing in Austin, Texas, and what this would allow us to do is to expand that manufacturing base. So as I think about the business, I think about the business as a triangle. So the base of the business is the manufacturing and creating of products. So that covers the expenses for the business. Then the licensing, we go into markets that we are not organized or capitalized to be able to address, like full-blown automotive transmissions. We license those to other markets. But for the markets that we can get a great return for our shareholders and be very economically efficient, we would look to manufacture that. So the capital we would look to employ is to bring that manufacturing capability in-house and build manufacturing jobs.
Okay. Thank you, Mr. Klein. Ranking Member Clark.
Thank you, Mr. Chairman. This testimony is truly fascinating. I want to thank all of you for your testimony here today. My first question is for Dr. Is it Engel or?
Angel.
Angel.
You can call me Jim.
Well, thank you. Excuse me. The Jobs Act included some investor protections, including restrictions on the amount ordinary investors can invest in each company based on income levels. As you know, the SEC has grappled with balancing capital raising by small businesses with investor protections in the past. In your opinion, are investment caps enough to protect investors with limited wealth and financial knowledge from crowdfunding issuers?
By itself, no. In that whenever you have money, money attracts flies just like garbage attracts fleas. And so that's why there are other good things in the Jobs Act, for example, that require criminal background checks of the people running these operations, because we don't want the fraudsters to come in, set up, bogus operations, sell them on the Internet, and run away with the proceeds. And, so, yeah, definitely this is something that's contemplated in the Act, and we just need to move forward with it.
I want to follow up on a question from your written testimony. You pointed out the challenges public companies face with regards to possible litigation, and how that can be a disincentive for private companies to go public. Given the litigation, can at times be an investor's only recourse. How would you mitigate that concern for private companies who may want to go public?
Well, one thing is that Congress and the SEC can create various safe harbors for disclosure, in that whenever something bad happens to a company, that not only do the stockholders suffer because the price goes down, but then the strike suits come in, and basically the shareholders end up suing themselves and paying twice. So better safe harbors, I think, are one very important thing. But you're right, we need to strike a balance, and that is a tricky thing to do.
Let me thank you. To Mr. Rustagi?
Yes.
As someone who has successfully used the Kickstarter platform to raise capital for your small business, what recommendations would you make to the SEC to ensure that new equity-based crowdfunding rules are workable for both investors and issuers?
So I think that's really interesting. With Kickstarter, what happens is a lot of it is centered around the companies themselves and the videos that create. And so as Chairman Schweikert was mentioning, a lot of it is very review-based. So there's a lot of back and forth there. I think the SEC would have to create something very simple. If they were to, just from the company's perspective or from the investor's perspective, I would want a lot of that regulation bottled up into the crowdfunding or crowd investing platforms themselves. It is imperative that the system is very, very simple. The biggest thing in startups is time, right? So the longer something takes, the longer the process takes, the more you spend on legal, the less likely it is that you are to use that. And so a lot of friends and colleagues of mine have been coming to me asking about Kickstarter advice because it is such a simple and elegant tool. There is a large back end for the companies, and there should be for investors as well.
And my final question to you is, what is high-tech apparel?
The eternal question. The eternal question. So we create synthetic materials that have specific properties. So the easiest one to explain is the dress shirt that I'm wearing. So a regular dress shirt has issues with wrinkling and holds moisture. This one does not. So it has special properties like you can wear it for 4 or 5 days because it doesn't smell. It has an antimicrobial coating. It has a phase change material inside of it, which is the same thing used in spacesuits. So it can hold your body heat, store that. So if you're out on a hot day, it'll pull that heat away. And then if you go into a cool environment, it'll release it back to you. So it's basically, as the blog TechCrunch put it, a magic shirt.
Very cool.
Thanks.
The magic shirt. Thank you, Mr. Chairman.
Yeah,
It
it just
didn't
sets
mean
your
to
mind
picture it.
erasing, doesn't it? Mr. Bentivilio.
Thank you very much, Mr. Chairman. And I think it's more appropriately named the Smart Shirt.
Thank you.
Yeah, it's a very good idea. Actually, my questions are for Ms. Peters, and I'm sorry I wasn't here to hear your initial, but I got the gist of it. And I have a few quick questions. The startup, somebody wants to raise money for a good idea, what they think is a good idea, they should put together a business plan, I'm assuming.
Right.
You help them with that? And do you have a format or a style?
There are a number of tools that startups use. There are some technological systems that they can go on that show them what they need to do, how to put up an executive summary, a business plan. They need a business plan for their business. I mean, we don't write that for them. If they're not capable of writing that, that's one of the signals we would have about how likely they are to succeed. They need to be able to understand and provide us with, financials and financial projections and the basis for those projections. So there are a whole array of templates that you can see on the Angel Capital Association site for entrepreneurs. There are a number of other sites that do that as well. These have been around for many years, and then also entrepreneurs come through economic development, through incubators in their towns, through accelerators, through tech transfer offices of colleges and universities, and frankly, a lot of the schools that used to promote their MBAs are now promoting their masters in business entrepreneurship, not administration, and so you're finding entire course curriculum around how to create a startup and develop the sources of capital that you need.
That's great. That's great. One other thing, Mr. and I'm sorry, Rustagi?
Rustagi.
Yeah. In another committee, we were discussing military uniforms, Is there any chance you could get involved with us on that, in developing a smart uniform?
I could speak with my former partner about it. There was an SBIR out about a year and a half ago that we were going to apply to, but certainly, yeah.
Well, that'd be great. And just one last question. How can I get you to come to my district and give a seminar on how to do a startup?
My email is just my full name at gmail.com.
Great. Thank you very much. Thank you. I yield back my time, Mr. Chairman.
Well, that's not fair. We wanted to get them to our district first.
You're going to be fought after.
Thank you. This is one of those unique occasions. I have sat through hundreds of hearings from, from my time in the state legislature to here in Congress. As a collection of witnesses, you're singularly the most interesting group I think I've ever had in front of me, because it's rare for me to look out and say, I'd love to sit down and have a coffee with each one of you. So thank you for joining us today. You may find that we may send you some questions to put into the record. So, and let me see, make sure I do the proper closing. Okay. And with that, I ask unanimous consent that the members have 5 legislative days to submit statements and supporting materials for the record without objection. So ordered. The hearing is now adjourned.
Thank you very much.